The court should deny defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Heard herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Heard physically abused him. She's the abuser in this courtroom. As to damages, they are presumed here because Ms. Heard's false allegations of domestic abuse, sexual assault, and rape constitute defamation per se. When they were pitching the op-ed to the Washington Post, they stated, "Hey, Michael, wondering if we might interest you in a piece by Amber Heard, who, as you may recall, was beaten up during her brief marriage to Johnny Depp." This is an article that was in USA Today and specifically ties Amber's statement in her op-ed piece to Johnny Depp. And when Jessica Weitz, who actually wrote the op-ed that Ms. Heard later adopted, she says, quote, to Mr. Doherty, "So much for not mentioning JD," which makes her Instagram post 2 days before the trial began, that she didn't mention Mr. Depp, all the more outrageous. So it's very clear that the ACLU and Ms. Heard intended. That was the whole purpose of this, so that they could get interest in this and it would coincide with the premiere of Aquaman, because otherwise no one would have been interested in anything written by Ms. Heard. Mr. Doherty also testified that Ms. Heard only paid 1.3, actually she didn't even pay all that, out of the $3.5 million that she had pledged to the ACLU, and then they helped her lie about it. And it's one thing, Your Honor, for her to stiff the ACLU, which frankly played a reprehensible role in this case. It's quite another for her to fail to honor her obligation to the Children's Hospital of Los Angeles with sick and dying children, and that she failed to do as well. And as Your Honor has mentioned, the fact that she put her name on that article means that she is responsible for all of those statements, which she specifically adopted later. And I'll go through the other two statements quickly, Your Honor.
Well, can we stay on this one for one moment, though?
Yes, Your Honor.
Because do you agree that the only evidence before that we've heard in this trial, as far as the title of the op-ed, is that even Mr. Doherty, I believe, testified to it, that it was something that Washington Post wrote?
Well,
for the one online.
He's not our witness, Your Honor. That's a witness from the ACLU.
Well, I understand, but it's the only evidence I have.
I respectfully disagree, Your Honor.
All right.
What the only real evidence Your Honor has is Plaintiff's Exhibit 1, which is Amber Heard putting her name on the entire article, including the title. That is the only evidence before you. The ACLU was a co-conspirator with Ms. Heard, and whether they say, oh, maybe the Washington Post wrote it, that's not the end of the story. All she has done is create an issue of fact as to whether she wrote the title or not.
So you're saying just having that exhibit in evidence is enough?
Absolutely. Absolutely, Your Honor. Her name is on the article. Okay. What does an average reader expect? So that alone is sufficient to beat a motion to strike. If they want to come back later and say, gee, she didn't write the title, as if that were a defense, I hope they make that argument. I hope they make that argument to the jury, because it's about as credible as her argument that, oh, I wasn't referring to Johnny Depp. She didn't have to. And the testimony of Terrence Doherty was very clear that when they took out the references to Johnny Depp, no one was interested in this article anymore. So she said, put it back in, put it back in. Make it more spicy so people would read. Otherwise, she couldn't get it in the Washington Post. It would be back in Teenage Vogue, which is the other publication that was considering publishing it, because no one was interested in what she had to say unless she was defaming Mr. Depp. But everybody and his grandmother testified that Ms. Heard was referring to her bogus ex-parte TRO that she obtained on May 27, 2016. And it was interesting that Mr. Depp's own lawyer said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex-parte TRO. And Ms. Heard herself, the evidence shows, knew that Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country, was already in New York at the time of this TRO, and was heading to Europe for several weeks. So she knew she didn't need any protection from him. This was just a scam for her to get the $7 million in the divorce settlement that she said she gave to the ACLU. She swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed instead. Mr. Depp, Ms. Dombrowski, Mr. Carino, Mr. Wiggum, and the inimitable Mr. Doherty of the ACLU, which lent its once respected name to Ms. Heard's defamation. So while Ms. Heard may have avoided any direct mention of Mr. Depp's name, there is extensive testimony and evidence in the record showing that the implication of her op-ed could not be more clear, i.e., that Mr. Depp abused Ms. Heard during the course of their marriage. Let's move to the falsity of Ms. Heard's ever-evolving and ever-escalating change of IPV and sexual assault. Mr. Depp's sworn denial is all he needs to survive a motion to strike, but there's a lot more than that, Your Honor, and I'll try to be brief. 3 police officers, actually 4, but the 3 who testified already, Officers Sines, Haddon, and Gatlin, testified unequivocally that Ms. Heard did not have a mark on her on the evening of May 21, 2016. Officer Melissa Sines on jury trial day 10. Question, did you provide a copy of this pamphlet to Amber Heard? Answer, I did not. I didn't identify her as a victim of domestic abuse. The next day, Officer Melissa Sines. Okay, at this time, did you notice any injuries on Ms. Heard? Officer Sines, I did not. Question, okay, were you looking to see if she had any injuries on her at the time? Officer Sines, yes, I was. Question, and so you were looking to see if Ms. Heard had any injuries and you determined that she did not. Is that accurate? Officer Sines, correct. Question, okay, and was the lighting good enough in the hallway for you to make that determination? Answer, yes, the hallway was well lit. Officer Gatlin's testimony was the same, and he had the body cam. Officer Haddon's testimony was the same. The testimony of nurses Debbie Lloyd and Erin Borem, who, like the police officers, did not work for Mr. Depp. In fact, they worked for Dr. Kipper, also belie Ms. Heard's false allegations of abuse. Isaac Baruch and Alejandro Romero both testified that they saw Ms. Heard repeatedly and in the clear light between May 21, 2021, which was the last time Mr. Depp saw her before leaving on the Hollywood Vampires tour. The next time he was to see her was when Ms. Heard begged him to come see her in San Francisco, which is hardly the act of a domestic abuse victim. So we have Isaac Baruch and Mr. Romero saying that they saw Ms. Heard repeatedly in the interval of time between May 21 and May 27th, when she obtained the farce ex parte TRO, and they saw no marks on her face and no swelling. 2 witnesses, Mr. Baruch and Brandon Patterson, saw the video of Ms. Heard and her sister Whitney pantomiming the fake punch after this alleged incident of abuse. Ms. Heard's former personal assistant, Kate James, and several other witnesses, including Dr. David Kipper, saw no violence by Mr. Depp and no injuries to Ms. Heard. Indeed, witness after witness has come forward to testify that Ms. Heard, far from being a domestic figure representing domestic violence, unquote, is in fact a recidivist perpetrator of domestic violence on Mr. Depp and others. We have the testimony, the harrowing testimony of Mr. Depp himself, who described several witnesses. One, as Your Honor will recall, when he was hiding in the bathroom after escaping one of her attacks, and she claims to have hurt her foot kicking the door. Mr. Depp opens the door to see if she's hurt, and then she kicks the door in on him and punches him. We have the incident of December 15, 2015, when Ms. Heard threw punches at him wildly at the back and side of his head. Mr. Depp testified that he ducked and covered to protect his face. Eventually, he turned around to grab her and stop her arms from flailing. December 15 in the Bahamas. During an argument, Ms. Heard grabbed a can of mineral spirits and threw it at Mr. Depp's face, striking him in the forehead, bridge, and nose area, and the jury saw a photograph of the bridge on the bruise of his nose. We have testimony from Mr. And by the way, Tara Roberts, who is the manager of the island, confirmed that the incident with the mineral spirits. You have Mr. Depp's testimony of what happened on April 22nd, 2016. And we've heard testimony today from Aaron Borum-Filati that Mr. Depp was very responsive, was very sociable, was not in any way inebriated that day when Ms. Heard says he was, and she attacked him that night as well. And I'm getting to the end of this, Your Honor. We have Ms. Heard's own admissions. We have her admitting to hitting Mr. Depp, and her only contention was that she wasn't punching him, she was just hitting him. We have testimony from Travis McGivern that on February 23rd, 2015, Ms. Heard threw and hit Mr. Depp with a can of Red Bull and then sucker punched him with a closed fist. Finally, we have the rather stunning testimony of Ben King, quite a credible witness who accompanied Ms. Heard on the flight back from Australia, where Ms. Heard admits to him in a rhetorical question, quote, "Did you ever totally lose it on someone you love?" Which was, we would respectfully submit, an admission of her severing the top or the tip of Mr. Depp's finger. Your Honor, again, the lies that have already been exposed that Ms. Heard has told about the charitable contributions, the incidents in this case, and again, I'll just cite a couple of more. The testimony of Isaac Baruch, when Mr. Baruch saw Ms. Heard on June 3, after she'd gone through with the sham ex-party TRO, and Mr. Baruch was asked, did she say anything in response? And Mr. Baruch testified, yeah. In response to that, she, meaning Ms. Heard, looks at me and said, "I told Johnny I don't want anything. The lawyers are making me do all of this." And that's what she said. Well, the lawyers are making her do all of that. And apparently she wanted the $7 million for herself. She even lied about the final insult left on the marital bed after her 30th birthday party. And it was quite telling that she admitted to Starling Jenkins, a former United States Marine, that this was a terrible prank gone awry. Well, she lied about that too. In fact, she said Mr. Depp was crazy to even allege that she could have done such a thing. Well, she admitted it to Mr. Jenkins. Mr. Depp does not have to prove damages because this is defamation per se. In fact, these involve some of the most heinous crimes any man or woman can be accused of. However, he has done so. Jack Wiggum tested yesterday that the impact of the op-ed was catastrophic on Mr. Depp's personal and professional life, that it was a $22.5 million loss on Pirate 6 and another $20 million on others. And just to respond to Mr. Rottenborn's citation to the Lakova case, which we hadn't seen until he mentioned it today, I would only note, Your Honor, that defendant admits that she tweeted a link to the online version of the op-ed at paragraph 97 of her answer, though again, the admission of Exhibit 1 is more than enough to survive the motion to strike. And the Lakova case at 995 F3rd 134 holds that republishing a hyperlink doesn't necessarily start the statute of limitations, not that a hyperlink cannot be defamatory. So with that, Your Honor, we respectfully request that the court deny the motion to strike in full, and let's hear from Ms. Heard. Thank you, Your Honor.
Yes, sir. Thank you. Your motion?
Thank you, Your Honor. I can only assume that Mr. Chu wrote that speech for an audience outside the court because it didn't really address my arguments. I'm going to focus on what our specific arguments are for the motion to strike, Your Honor. I can tell you she's not the abuser, and if the case moves forward, she and her witnesses will put on even more evidence of the physical abuse she suffered at the hands of Mr. Depp. But that's not the basis for our motion right now, Your Honor. And the basis for our motion is the clear and undisputed evidence of non-physical abuse. By his definitions, by his standards, by the standards of his expert, there is no dispute that Mr. Depp abused Amber. But even under their standard, the undisputed evidence is that Mr. Depp did commit abuse against Ms. Heard, and therefore that those first two statements were false. That's our argument on that. And Mr. Doherty testified that the Washington Post wrote the headline. That is the only evidence, Your Honor. I understand he says, well, Exhibit 1 has her name on it. Exhibit 1 has her name on it. But the only evidence in this case about who wrote that headline is Mr. Doherty's testimony. It is undisputed. They could have put anyone else on. They could have called Ms. Heard for that because that was not part of the stipulation at the pretrial conference. It was only the tweet that we talked about, Your Honor, and they chose not to do that. Now, Ms. Heard will testify she didn't write that headline, so it wouldn't have helped them. But they've had 3 weeks to put on their case, Your Honor. They've controlled the playing field of evidence. There is no dispute that Ms. Heard did not write that headline. No dispute. Simply saying, well, her name is attached to it, that can't overcome the testimony of the ACLU. They call them a co-conspirator. Of course, Mr. Depp chose not to sue them. But the testimony of Terrence Doherty that she didn't write that headline, that takes care of the sexual violence headline, Your Honor. And I'm not going to take up any more of the court's time addressing portions of Mr. Chu's argument that don't go to our motion, unless Your Honor has any specific questions. But I want to be respectful.
All right, thank you, sir. All right. For this motion, I've taken the arguments of counsel, and last night I reviewed all of the evidence that has been submitted in this matter. So as to the second and third alleged defamatory statements, at the motion to strike at this juncture, I view the evidence in the light most favorable to the plaintiff and reasonable inferences from the evidence to the plaintiff. And if there is a scintilla of evidence that a reasonable juror could weigh, then the matter survives a motion to strike. In this matter, there is evidence in the case that a jury could weigh that the statements were made by the defendant, that the statements were about the plaintiff, that the statement was published, that the statement is false, and the defendant made the statement knowing it to be false, or the defendant made it so recklessly as to amount to a willful disregard for the truth. The weight of that evidence is up to the fact finder, so the motion to strike is denied as to statement 2 and 3. The motion to strike as to statement 1, I'm going to take under advisement because if it's not a stipulation, I'm not sure what it is, but there seems to be an agreement that the tweet of Ms. Heard is part of the plaintiff's evidence, which is not in evidence at this point. So I can't rule on that statement whether or not it is just a tweet or if it's some sort of republication or something. I don't know because I haven't seen it yet. So as to the motion to strike on statement 1, I'm going to take an advisement because ruling on it now, it would be premature because I just don't have that evidence in the case, okay?
Thank you very much, Your Honor.
All right.